Former federal prosecutor and president of West Coast Trial Lawyers, Neama Rahmani, joins me now for more on this. Neama, thanks so much for coming on. You know, Jules is claiming to be the creator of this catchphrase, but someone else already filed a trademark application for it. So how do trademark rights work, and what would someone have to show in order to claim ownership of a catchphrase like this?
Well, Diane, registration is important, but what's more important is whoever first used the mark in commerce. And commerce means the sale of goods or the rendering of services. So obviously a thought isn't enough, and even a social media post isn't enough. But if Jules was the first to use it in an ad or to sell merchandise or some other goods or services, she would own the mark regardless of whether Jefferson Bates registered it first.
That said, I mean, the catchphrase is catching on because of Jules's social media posts. So the level of virality to this video, is that enough at all to show ownership and fight this trademark application at least?
Going viral isn't enough, unfortunately, Diane. You have to use it in some sort of business related purpose. And obviously that definition is very broad, but to the extent that, Jules is making money off the mark, going on late night talk shows, selling merchandise, I mean, she's going to own the mark. And the U.S. Patent and Trademark Office, which processes these applications, they're backed up for months. They're processing applications from the beginning of the year. So Jules definitely has time to show the office that, she's been using the mark. She had it first. So she's going to own it. The fact that you have a trademark troll, allegedly like Jefferson Bates, is trying to get the mark, even though Jules has used it first, that's not going to be enough.
So what happens if Jules loses or doesn't pursue a legal battle here?
Well, you still have common law rights to a trademark, even if you don't formally register it with the USPTO. Now, it's best practice to do so because once a mark is registered and you have that circle with the R in it, that gives notice to the entire country and the world that you own the mark. So it definitely gives you the most protection, but you can still own a mark and have that TM next to it, even if it's not registered. So she's still going to be okay, as long as she was using the mark first in commerce, even though Bates may have tried to register it later.
All right, former federal prosecutor, president of West Coast Trial Lawyers, Neama Rahmani. Neama, thank you.